My name, as Kateva said, is Amy, and I head up the training and the well-being side of the business. My background is as an employment lawyer. So before I joined Lock, I was working with employees who were maybe a bit cross with their employer and looking to take action. But predominantly, I worked with employers to try and help them stay on the right side of the law, do things properly, and treat their people well. These days, I mostly design and deliver training across a range of different topics, whether it's helping people be better managers, helping people understand the law. And I also am a qualified mediator, so I do a bit of that conflict resolution piece in the workplace. In terms of what we're looking at today, what I wanted to do was to take you through the employment life cycle and to think about the rights that you have as an employee during that life cycle, and also some of the responsibilities that you have to honour as well. Because I'm conscious that everybody on the call might be at a different point in the life cycle. Maybe you are looking for a new role. Maybe you are in the process of actually applying for a new role. Maybe you're in a role and you just want to understand more about employment law and the full picture of rights and responsibilities in England and Wales. So I'm hoping to walk you through the piece that comes before we start a role, the application piece and the things to be aware of, to then move into some of the key elements of the employment relationship. So thinking about things like holiday and sick pay, some of the formal procedures we can be subject to. And then I'm going to finish up by thinking about how does employment come to an end and what are the key things we need to be aware of when that happens. Kateva mentioned that we would love to hear your questions, and there are never any silly questions. If you're thinking it, somebody else is probably thinking it too. Please do feel free to pop your questions in the chat box. If it's something that's really relevant to what I'm talking about and I have the opportunity, I'll try and take that question there and then and deal with it. But otherwise, there'll be space at the end for questions and I'll work through the chat box at that point. So please do ask away. We'd love to hear your questions and your queries. But let's not wait any longer. Let's get going with the webinar itself by thinking about the first stage of that employment life cycle, which is the bit before you start a job. So imagine the situation. You're looking for a role. You find a role that you think is really suitable to you. You want to apply. Well, generally speaking, there are two ways that employers will ask potential candidates to apply. They might ask you to complete a candidate application form where you fill in information that they specifically request. Or alternatively, you might be asked to provide a CV, which is a summary of you, your employment history, your education, your qualifications. What I just wanted to say at this stage is whatever process an employer asks you to follow, whether that's application form or CV, if you have any difficulty with that process, it's worth reaching out to the employer to see if they can adjust the process for you, particularly if the reason that you're having difficulty with it relates to a disability. Because in England and Wales, there is equalities law that says that if you have a disability that makes something more difficult, an employer should try and reduce that difficulty. So they might provide you with another way of completing that application form or even another way to apply. So don't be afraid to ask that question. But assuming it's a CV that the employer wants you to submit, I just wanted to provide a few pointers around how we complete a CV. You would start by setting out your name and your contact details, but please don't be tempted to put a photo in the CV, to put your age, your date of birth, or your gender. When employers are doing recruitment, when they're hiring people to come and work for them, it's really important to ensure that they don't discriminate, that they don't allow bias to creep in. So ensuring that you're not putting information like your age, your gender, or a picture of yourself can really help them reduce any possibility of discrimination. Then once you've set out your heading, you're going to summarize your employment history. Start with the most recent role you held and work backwards, and really highlight the roles and responsibilities that relate to the job you're applying for so that you can show you've got really relevant experience. Where education is concerned, summarize those qualifications, any internships you might have done, your schooling. But again, just don't put the dates that you attended certain schools or institutions because that can give age away. You might then want to summarize any skills you have, particularly again, if they're relevant. If, for instance, the job involves driving, you might want to stipulate that you hold a driving license. And you can then say a little bit about yourself in a CV, your interests, your achievements. Again, if you can relate them to the job, even better. And the final piece of the puzzle is to set out the referees that you want to speak on your behalf. Most employers will ask for two referees, and they generally will ask for professional referees, essentially people you've worked with in the past. So you can list the contact details for those people, but just be sure you've checked with those people they're happy to be given as referees before you put their details in your CV. They might not be terribly happy if they get a call from an employer asking them to provide a reference when they didn't know you were going to give their details. So those are the kinds of things that we were looking for in a CV. Bear in mind the importance of only putting things in that are true, verifiable, accurate, because some employers will carry out checks on the information that an employee provides in a CV. Assuming you've submitted your CV, the employer will then embark on a selection process. This is how they work out who they're going to hire for the role that's been applied for. And employers will use all different techniques to select a successful candidate.
Excuse me. Is it possible to ask questions on this stage, on the first stage about
I think ideally everybody would put them in the chat, but if there's something really pressing at the moment, feel free to ask me just in this one instance.
It is about first step of employment, and you mentioned all documents, but it's always about cover letters. I always meet this demand about cover letters,
Yeah.
and but for some reason I don't want to provide it. Is it my right or it's my obligation?
So I would say there's no obligation to provide a cover letter from a legal point of view, but an employer will want to see people following the process that they've stipulated. So if they have said, we would like a cover letter and a CV, then it could be that as part of the shortlisting process that we've got listed on the slide, anybody that doesn't comply with that process is not taken further to the next stage. So what I would say is there's probably no legal requirement to complete an offer letter, but it's in your best interest to comply with the process the employer has requested that candidates comply with.
And in fact, it's about sell myself, because I gave them all fact of my biography and my experience in the CV. They have it in very details. In fact, I have to praise myself in this cover letter. I really don't. I'm from different culture, and I don't understand why I have additionally explain how good I am. I will have interview.
Yeah. I mean, I don't think you need to go into sort of close detail about your life or your experiences in the cover letter. I think it can be very simple and straightforward. I think you can be very polite and just say, dear sirs, dear sir, madam, whoever you're applying to, please find enclosed my CV. And then you can just summarize, if you want to, some of the key facts that you really want them to pay attention to, whether that's a really relevant previous role, really relevant qualification, something of that nature. I don't think it needs to be really, really lengthy or hugely detailed.
Thank you. If you don't mind, another questions about references. They would like to ask my previous employer about my qualities, but I'm not sure that they will hire me, and they will like disclosure my intention to leave previous job. I don't want it.
We will touch on references. So maybe would it be all right if we leave references for one moment and we'll touch on it
Yeah,
a bit later?
Thank
Is that
you
all right?
Yeah, absolutely.
Perfect. Thank you so much.
Okay.
Okay, so as I said, there will be various ways that employer organizations approach the selection process. Generally speaking, there'll be some sort of shortlisting exercise whereby CVs or application forms are sifted to work out who's going to be taken forward to the next stage and who isn't. And that can come down to a ranking, that can come down to relevant experience, relevant qualifications even. Whoever comes through the shortlisting process is likely to undergo some kind of interview, often with a panel. Sometimes there's multiple rounds of interviews, depending on the role. And some employers will even utilize assessments. Maybe you have to complete a written exercise. Maybe you have to come along and do a group exercise. Maybe you have to do a presentation. It can take different forms. But as I said in answer to that question, I would recommend you engage with that process because that's what the employer is looking for, albeit if there's a really good reason that you're struggling to comply with or engage with that process, raise that with the employer, particularly, as I say, if it relates to a disability. And hopefully, having gone through that selection process, you'll be successful. The job will be offered to you. What you can expect to happen at that stage generally is that you will receive an offer letter, a letter that sets out the main terms of your employment relationship. So things like your pay, the hours you're going to work, where you're going to work from, the holiday you're entitled to. My recommendation is read it really carefully. If something doesn't match up with what was said in the interview, go back and ask about it. If something doesn't make sense to you, go back and ask about it. Because if you sign it, you're technically bound by a contract at that point. So be sure to raise any questions and queries you might have before you sign on the dotted line. Thereafter, having confirmed that you would like to accept the role, the employer will go about conducting some checks. All employers of any shape and size have to conduct what's called a right to work check on all employees. This is a check to ensure that the employee has the right to work in England and Wales from a legal point of view. And it generally has 3 stages. It will involve the employer asking for sight of the employee's identification document, their right to work document, then checking its validity, checking it's a proper document, and then taking a copy of it, dating that copy, and retaining it with a note of who carried out the check. And these checks are really, really important. If we don't, as organizations, do them, we can face significant fines. So all employers do this for all employees. And as I say, it applies to all employers of any shape and size, however many people they employ. Conversely, there are other checks that only some organizations will do. So for instance, a DBS check is essentially a criminal record check. So employers in some industries have to do this. For instance, me being a lawyer, I had to be DBS checked before I could qualify as a lawyer and then work at my last firm, because of the importance of ensuring that a lawyer doesn't have, for example, a fraud or a dishonesty conviction. So depending on the industry you're applying to work in, you may be subject to a DBS check. Schools will have to do these kinds of checks. Other organizations will carry out more general background checks. This might involve checking your employment history, your education history. If you're applying for a role that involves financial responsibility, it might involve some kind of credit checks. There could be other checks that your employers do, but those are the ones that tend to sort of bubble to the top. It's also worth you just doing some checks of your own. So for example, you might want to check that the contract with your current employer, the one you're leaving, or your last employer, doesn't contain anything that stops you working for the new employer. Some contracts of employment will contain what we call restrictive covenants, and they are rules as to who you can go and work with when you leave the employer to whom that contract relates. For example, they might stop you going to work with a competitor. So just check your contract and make sure there are no covenants that stop you going where it is you want to go for your next employment. Next stage is to receive your contract. Now, this is what we call a day one right. You are entitled to have sight of your contract by at least your first day of employment. Most employers will provide it well in advance of that. If you haven't got it, you can absolutely request it. It's really important you see it because, again, you want to read it carefully, raise anything unexpected, raise anything that you don't understand. And I would also recommend checking that it definitely is an employment contract, not, for example, a contract relating to self-employment, where you're in business for yourself rather than being employed by a business. So look out for the language that the document uses. Does it call you an employee, or does it maybe call you a consultant or a contractor? Just be really diligent in the checks you make. There's some key information that has to be contained in a contract, and I've listed a summary of that on the slide. Just to point out a few things, the probation period will probably be set out in your contract. And what that is a short period at the beginning of your employment, usually around about 3 months, during which the employer works out if you're right for the job, and equally, you can work out whether you want to stick in the job. During that period, you'll probably be subject to more reviews of your performance than you might be later on. You might have to go to a few more meetings. And as I say, at the end of the period, a decision is made about whether the employment continues on or whether it comes to an end. So just be aware that you'll probably be subject to a probationary period when you start. Also check the length of the contract. Many contracts are what we call indefinite. So you start and then the employment carries on as until you decide you don't want to be there anymore, your employer decides to bring your employment to an end. But there are what we call fixed term contracts. These are contracts that are for a short period, say 6 months or a year, maybe to cover a particular project. Make sure that if you think you're on an indefinite contract, your contract doesn't actually say you're only going to be there for 3 months, 6 months on a fixed term basis. In terms of the other details, there'll be a summary of your job title, there'll be a summary of your pay arrangements. So how much you're getting paid, how frequently will it be paid, when in the month will it be paid, so you know how to plan. There'll be a summary of your hours. Some people will have fixed hours. I, for instance, work 9 till 5:30 on all of my working days, but other people will work shifts. There are also 0 hours contracts where you have no fixed hours, but your employer will reach out and offer you work as and when they have it. So be sure that the hours that are set out match up with what you were expecting. You might also find that there's mention of benefits in your contract, which would be lovely. These can be things like health insurance, life insurance, gym membership. There's no requirement for an employer to provide benefits, but they might choose to do so, and it's worth just knowing what they are. There'll also be mention of the notice that you will need to give if you want to bring your employment to an end, and the notice the employer will need to give if they want to bring your employment to an end, and we'll touch on that in some more detail down the line. Once you've read your contract in detail, you'll also want to look at the staff handbook. This is often quite a lengthy document, but it sets out the key policies that apply in your place of work. It's the code of conduct for how employers expect employees to behave. It tells you how to go about doing certain things like booking holiday, reporting sick leave, and it will also tell you how certain situations will be handled, like situations where bad behavior has arisen or where performance is slipping. So do read it carefully. Sometimes employers will get you to sign to say you have indeed read it. So do make sure to ask any questions if you're unclear on any aspect of it. And the final thing to look at from a documentation point of view is your job description. This document will set out the key duties and responsibilities of your role. It probably won't say absolutely everything you're going to be required to do, because it could go on for pages and pages and pages, but it will be the really key points that relate to your role. If you don't get given one, I'd recommend asking for it so you can really understand what's going to be expected of you in terms of how you perform your role. Okay, let me just have a look at the chat because I could see some questions coming through there and I don't want to move on unless we've dealt with them. So Marina, we dealt with your question about cover letter. Anna, what happens if the company does not want to give references? We'll come to references if that's all right, Anna. We will get to that. A 0 hours contract, what's acceptable? So a 0 hours contract, as I say, is one where an employer doesn't stipulate specific hours, but says it will contact you as and when it has work available. What I would say is that there are changes in the law that are coming probably next year that will probably make 0 hours contracts less common, because they're going to restrict how an employer is able to use a 0 hours contract. So we probably will see fewer of them in use going forwards. Good question, Mo. What does DBS stand for? It stands for Disclosure and Barring Service. It used to be CRB, Criminal Records, I think Bureau, but now it's DBS. Essentially, it's a criminal records check. Uh, May I ask, what does mean detailed DBS check? What does this check include? Yeah, so a DBS check, there are different levels that an employer can carry out, but there's a basic level and a sort of escalated level. It'll depend on the nature of your work, what kind of level is carried out. Roles that include working with children, for instance, might carry out a higher degree of DBS check. Let's just have a look at this next one. If just offer in email, does it equal the contract? Or before contract signed, just job offer in email? Yeah, so if you get an offer in writing and you accept it in writing, a degree of contract is formed by virtue of that exchange. And actually, if you start working for someone and you haven't got a written contract, you still have a contract, it's just not written down. So a contract can arise even without writing or pen to paper being made. Uh, yeah, Mo, a good question. How to sort of uncomplicate the complicated language. I would recommend speaking perhaps with the HR team because I think maybe they will be able to explain the jargon. Sometimes it's job related jargon, sometimes it's legalistic jargon. So I would recommend speaking with the HR team just to try and work through any elements that you're struggling with. If there isn't an HR team in post, then I suppose always rely on any friends that you've got that might be able to work you through that. You can also contact the next slide deals with this, in fact. You can contact this organisation, ACAS. You might have heard of ACAS before, but they are a service in England and Wales that gives advice on employment rights and responsibilities. Now, they wouldn't be able to review your contract for you and tell you every clause and what it means, but if you had something you were particularly concerned about, you can call them and you can have a discussion with a conciliator or an advisor. So I do think when you're thinking about taking on work in England and Wales, knowing about ACAS is a really good starting point. You can contact them whether you're an employer or an employee. They provide completely free advice and it's totally impartial. So if you're ever in a role and you think, I'm not sure I'm being treated quite right, or if your employment ends and you don't think it's been legally ended, you can reach out to them for a bit of input. They also offer some training, some of it's free. So, again, just keep an eye out for that. And what they also do is if an employee, for example, has been sacked from their job and is unhappy about it, and they think it's been done unfairly, and they think they might want to sue the employer, then ACAS can try and resolve the issue without a court case being brought. So I would recommend you visit the ACAS website. I've put a link to it on the slide because it's a great organization to be in touch with and aware of. Somebody's asked me, what does ACAS stand for? And I'm not going to even pretend that I'm going to get it right. But essentially, it is a conciliation service. So when I say conciliation, that's about bringing people together and resolving issues. Hopefully that sort of summarizes the meaning of the acronym ACAS. Okay, let's think then about what stuff we need to be really conscious of when we're taking on or when we've just started in a new role. And I've put pay as the priority because funnily enough, we don't go to work out of the goodness of our hearts very often. We do need to make sure we're getting paid and paid appropriately. So some things to be aware of. All employees are entitled to the national minimum wage. That's what NMW stands for, the national minimum wage. Of course, you can get paid more than that, and many employees are, but you must not be paid less than that. I've put the rates on the slide, and what you'll see is they vary depending on an employee's age. So if you are over 21, then your national minimum wage is £12.21 per hour. All employees are also entitled to a pay slip, and that will then set out the amount that you're being paid over your pay period. Some employees are paid weekly, some fortnightly, some monthly. What the pay slip will also do is set out the deductions that will be made from your earnings, from your pay. And the key deductions to be aware of are PAYE and pension. So let's just break them down. PAYE stands for pay as you earn. And essentially, what it's all about is the employer deducting from your earnings the contribution that you need to make to income tax and to national insurance. So instead of all your pay going to you and you then having to pay your tax and your national insurance, the employer takes care of all of that before you get paid. So it's a really efficient way of making sure everyone stays on top of the tax that they need to pay on their earnings. So when you get your payslip, be aware you're likely to see, unfortunately, some money disappearing in PAYE. And the other deduction that you may or may not see is for pension. In England and Wales, we have the auto enrolment scheme, which is an automated pension scheme. The government basically decided people weren't saving enough for their retirement. So therefore, they wanted employers to set up pension schemes for all their staff and to contribute to those schemes as well. So what happens when you start a role is you will be enrolled in a pension scheme. You'll be put in a pension scheme as a default. That'll happen automatically. You can choose to opt out, to say, actually, I don't want to be in that pension scheme. And that's fine. Obviously, it's a great idea to save for our retirements, but not all of us are in the position to do that at all times. If you stay in the pension scheme, your employer will contribute 3% of your earnings to the pension, and you will contribute 5%. You can contribute more than that if you want, but that's the minimum contribution. So if you stay in your pension scheme, again, you will see these contributions coming out of your pay before it reaches you. I can see that a question has been asked about the difference between tax and national insurance, and it's a fairly good question. Tax is the deduction that is made from our pay as a result of us earning income. Everybody pays tax on the income we earn. National insurance is a slightly different charge. And essentially, it's money that's collected from working people to contribute to things like job seekers allowance, the NHS, the running of those sort of social security services in England and Wales. Okay, so we've thought about pay. Let's now think about holiday. We're going to think about a few different kinds of absence fairly quickly now. So everybody's entitled to holiday. And the way we look at that in England and Wales is we say everybody gets 5.6 weeks holiday per annum, per year, prorated to their working hours. So let me just explain what that means. If someone works full time, so they work 5 days a week, they get 28 days holiday a year. That is 5.6 times 5. I, for example, only work 3 days a week. So I get 17 days holiday a year. That's 5.6 times 3. So your holiday does depend on how many days you work each week, but it is based off a minimum, that 5.6 weeks prorated to your working hours. If you are a full-time worker and you get 28 days holiday a year, that might include the 8 bank holidays that we have in England and Wales. Many organisations will say 8 days of that 28 days you get, you have to take on the bank holidays that we recognise in this country. In some industries, that doesn't happen. So in, for example, the restaurant trade, restaurants are open on bank holidays and they want you to work. So in those kinds of jobs, you probably wouldn't have to take bank holidays. You probably have to work them. You can take the days on other occasions. It's important to make sure that you use all your holiday during the holiday year, because if you don't, you will lose it. So your holiday year might run from January to December. It might run from April to March. Whatever the time frame, when you get to the end of that period, make sure you've used all your holiday, because you won't get it next year. You won't get paid instead of taking it. Make sure to use it. It's your entitlement. If you want to take holiday, you have to give notice to your employer. Check your handbook. That will tell you how far in advance you need to give notice. And bear in mind that an employer can refuse a request for holiday if they've got a good reason. So please, please, please do not book any flights until your employer has confirmed you can take that holiday. An employer can require you to take holiday on certain dates. Many employers will shut over the Christmas period, and they might say you need to use 3 days of your holiday during the Christmas period. They generally will give you a lot of notice of this so that you've got enough holiday at the end of the year to do that. And when you're on holiday, you get paid as normal. Your normal rate of pay should apply. If you don't have fixed hours, an average will be taken of the hours you work to make sure it feels like normal pay. The next type of leave to have a think about is sick leave, because if you're unwell, you absolutely shouldn't be coming to work. We really don't want people coming in if they're too poorly to be there. That means they spread germs to everybody else, which might make the rest of the workforce feel unwell. It means errors are more likely. It just means people don't recover as quickly. So it's really important that you do take sick leave if you're unwell. If you're not going to be able to come into work on a particular day because you're unwell, you need to follow the reporting requirements that your employer has set out in the handbook. So that's why it's a really good idea to read that handbook early on in your employment to know what's required. If you're off for less than 7 days, you can do what's called self-certificating. So that means you come into work when you're better, you fill in a form that explains why you were off, and that's the end of it. If you're off for over 7 days, you will need to go and see or speak to at least your GP to get a fit note to cover that period of absence on a medical basis. In terms of what you get paid while you're off, if you are only entitled to the basic legal entitlement, which is called statutory sick pay, then you will get £118.75 per week. That's the current rate. It does go up generally every April. Importantly, do note that statutory sick pay is only paid if you are off for a prolonged period. If you're off for 1 day, 2 days, even 3 days, you actually have no legal entitlement to be paid anything for those days. Statutory sick pay only becomes payable from day 4. Now, the government recognises this is quite an unfair approach, leaving people without pay when they're unwell. So hopefully from this October, we might well see that change, and days 1, 2, and 3 will also become paid at the rate of statutory sick pay. So keep an eye on the news because the change could be coming here. Of course, some employers will pay more than statutory sick pay. Some will pay your normal contractual rate, but that's a decision for them. It's not a legal requirement. And the final kind of leave that we have in England and Wales is, if I can call it sort of as a classification, family leave. It's time off, sometimes paid, that people get if they are having a baby, supporting someone having a baby, or if they've gone through, for instance, a bereavement, an adoption, or a period during which somebody that needs their care is unwell. There are lots and lots of different kinds of family leave. Maternity leave is the leave that a person who is having a baby is entitled to, and anybody that's having a baby is entitled to 52 weeks off work. Only certain people will be paid for that time. They have to be eligible. So they have to have worked for their employer for a defined period and be earning above a minimum earnings rate. The person supporting the person having the baby will take paternity leave, and that's much shorter. They just get 2 weeks. And again, they have to be eligible in order to receive pay for that period. Again, you can find lots and lots of details out about these kinds of leave from your handbook. And if they're not set out, if the information is not set out in your handbook, you can absolutely ask your employer. One other kind of leave associated with family relations is the leave known as time off for dependents. So imagine a situation where an employee has a young child who goes to nursery, and suddenly the nursery is shut for the day. The employee would expect that employee at work, but they can't come in because they're having to look after their child unexpectedly. In that instance, an employee is entitled to the day off. They wouldn't be paid for it, but they're entitled to that emergency day off to sort out care for their child who would otherwise normally be at nursery. So it's worth knowing about that kind of leave because we all have things that crop up, whether it's relatives we care for or children we care for, where unexpected challenges present themselves. I'll just check the chat before I move on, just to see whether there's anything that's arisen in relation to those bits that we've just run through. So Mo, you've asked, is staying in the pension scheme mandatory? No, it's not. You absolutely can opt out of it if you don't want to stay in it. You must complete certain forms, so be sure to speak with your employer about that. And then, Natalia, you've asked, does that mean the number of holidays depends on the employer? Kind of, yes. As long as you're being provided with the minimum, which is for a full time employee, 28 days, then an employer can give you more than that if they want to. And some employers absolutely will do, but they cannot go below the minimum. Uh, can I please explain neonatal care leave? Absolutely. This is the newest kind of family leave we have in England and Wales. And it relates to parents who have a child who is born and requires a period of time spent in neonatal care. So that's intensive care because a baby is born with complications or very prematurely, for instance. The employee is allowed a week's additional leave for every week that that baby spends in intensive care. So it's a new kind of leave, but one that's been very gratefully received by parents whose children do find themselves in intensive care after birth. Okay, I'm just going to move on now to this next section, which just briefly considers some of the procedures that you might be subject to when you are an employee. So if an employer feels like your behavior has not been where they need it to be, if they feel like bad behavior has arisen, they might utilize what's called the disciplinary procedure. They might consider whether they can resolve things informally to begin with by a chat, but sometimes they'll think the issue is too serious for that. A disciplinary procedure has a few stages. It will sometimes start with suspension, where you might be told you're not allowed to come into work for a while. That suspension would be paid and it's only used in really serious circumstances. You might not be suspended, but you'll always be informed that an investigation is taking place. So an employer can't just decide, I believe this has happened, this is the action I'm going to take. They've got to explore it and investigate it. So they might speak with witnesses or look at documents. Then they have to invite you to a hearing to set out your side of the story, to give your case. And at the end of that, they decide what's going to happen. Maybe they'll impose a written warning. Maybe if it's very serious, they might consider ending your employment. Whatever happens, you can appeal the outcome by submitting a letter in writing. And at all of those formal meetings, so the disciplinary hearing and any hearing to consider your appeal, you will be allowed to bring somebody with you for support because it is a stressful situation. That person might be a trade union representative or a work colleague. Quite similar, but slightly different. If an employer feels that your performance isn't quite where they need it to be, then they might instigate a performance management procedure. Again, they'll think about informal resolution to begin with. They'll try and provide you with some support, maybe some training. But if that doesn't work, they'll move to a formal procedure. And again, it involves meeting with you to explain the concerns and to allow you an opportunity to explain your side of the story. This is a bit more of a joint effort than the disciplinary because here what we do is we put together a plan. How are we going to help you as the employee get your performance to the standard we need it to be at? A review period will be set during which the employer will expect you to make the improvement to your performance that's required. And if at the end of that period you've done it, you've improved, that's the end of it. If you haven't quite achieved the performance improvement that the employer needs, then they'll repeat the process. And if at the end of that second process, we're not where we need to be, you might find that your employment is brought to an end. But again, you can appeal the outcome and bring someone for support with you to all of those formal meetings. And you might be thinking, Amy, all you've talked about there is what happens if an employer is not happy. What about if I'm not happy? Well, this is how we deal with that. If you're not happy with something at work, go and speak to your employer, speak with your manager in the first instance, because many issues can be resolved informally through a chat. But sometimes you might feel it's too serious for that, or you might feel you've tried to resolve things informally and it's not worked. In those instances, you can lodge a grievance. That's a written concern or a written complaint that your organisation will then sit down and discuss with you. then go away and investigate and explore before coming back to you to say what they're going to do. They might decide that actually they don't agree with your complaint or concern, in which case you might either let it go or appeal. They might, however, decide they do agree with your complaint or concern and they're going to make certain changes, but you'll have a written outcome that you can review. That concludes the during employment piece. But to wrap up, I just want to touch on how employment can come to an end. Generally speaking, you as the employee might resign. You might say, I don't want to work here anymore. Or on the other side of the coin, your employer will say, we no longer want you to work here. We're going to bring your employment to an end by dismissing you. Sorry, I skipped forward. I just want to touch on one thing there. We mentioned notice periods a moment ago. You may need to make sure if you want to leave your employment that you give the appropriate notice. Your contract will tell you how much notice you need to give. Often it's a week or maybe even a month. Likewise, your employer can't just decide there and then that they no longer want you to be in their workforce. They need to give you some notice, other than in some very extreme circumstances. Again, the notice that you are entitled to will be set out in your contract. It must comply with the law, which says that you are entitled to a week's notice for every full year that you've worked for your employer, up to a maximum of 12 weeks notice. So, for example, I've worked for my employer for 3 years. So I would, on a legal basis, be entitled to 3 weeks notice if my employer wanted to end my employment. And the other thing that I just wanted to deal with here was references, because it's come up a few times. The key thing to note where references is concerned is that an employer is not obliged to provide one. They don't have to give a reference, even if you ask them to, even if your new employer reaches out to them. But if they do decide to give a reference, they cannot say anything that's untrue. That's the real key thing to recognize. If what they say is true and accurate about your performance, for instance, or about your attendance, then they can do that. They just can't say anything that's untrue. Generally speaking, where references are concerned, what we tend to see employers doing is only providing confirmation of the role that you held and how long you were in that role for. Most employers won't go much beyond that these days. So hopefully that deals with the questions that came up on references, but feel free to ask more if you've got them. And if it is the case that your employer is the one that decides to bring your employment to an end, they can only do that on one of 5 legal grounds. Redundancy means they don't need so many people to do the work anymore. Maybe they've lost a big contract, they just don't need as many staff. They can make people redundant. Maybe it's to do with your behavior, that's misconduct. Or maybe it's to do with your performance, that's incapability. Maybe it's a legal issue. Maybe you've lost a particular license that you need to hold in order to perform the role, and legally you can't stay in that role. Or maybe it's some other reason. This is kind of a catch-all, a wrap-up of everything else. This might involve falling out with colleagues that means both of you can't stay in the workplace anymore, for example. But as I said right at the beginning, if you have any concerns about how your employment has been brought to an end, please do speak to ACAS. They'll be able to give you a steer as to whether something has maybe gone a bit awry or a bit wrong. Okay, that concludes this presentation on the subject of employment law. I'll just check the chat and see what's come on through since I checked it previously. Mo's asked how to know the details of what has been reported in the reference by the employer. And is it true that companies cannot give a bad reference by law? So in terms of who sees a reference, generally speaking, they just go direct to the employer. And as to the employer that's requested them, and as to not giving a bad reference, it's not so much that they can't give a bad reference, they just can't say anything that's untrue. Whatever they say in a reference has to be factually accurate. So one would hope that most employers aren't gonna give a damaging reference, but the key thing that they have to comply with is that truth element.